Hi, everybody. Welcome. This is Janine from the library. Good to see everybody. I know a lot of you. We're really happy to welcome Beth Polner Abrahams today. She's going to be talking about wills and trusts and how important it is. And without further ado, Beth, thank you so much for doing this for us today. We're really appreciative.
Thank you. So before I share my screen, which will allow you to see the PowerPoint presentation, and that's the handout that Janine was referring to, I just want to thank the Long Beach Library for this opportunity. I love presenting and I love talking about the area of law or areas of law that I practice in. So my name is Beth Polner Abrams. I am a Long Island attorney. And I've been practicing law for almost 39 years. My areas of practice are estate planning, which is what we're going to focus on today, elder law, special needs planning, legal guardianship proceedings, which we'll talk about briefly. And I'm also a certified mediator, certified to mediate disagreements and disputes both outside of the court arena and inside in the subject areas that I handle. Mediation is an alternative to litigation. So this is a trust and wills and power of attorney healthcare proxy. We call those advanced directives. So I'm going to just take a minute now to share my screen. And let's see, beginning slideshow. And then I have to just switch my screens. Let's see. Okay, whoops. Can everyone see that clearly, or is it too small? I'm going to try and switch them if it's too small. So let me just see if I can do that. And
I can
so
see it okay.
you can,
Can you
is it,
guys all see it? Just nod if you can see it. And I think it's
so
pretty clear if you can't get it to go any bigger.
actually it's interesting because the actual Zoom program
Hmm.
is blocking some of the controls for the
Even with,
larger screen.
oh, wow. Even with a co-host capability, that's unusual.
Yeah, so I'm just going to try one more thing.
Yeah, take your
So
time.
let's just see if we can do that.
Usually the bottom right there's like a bigger, let me
Yeah,
just see.
yeah,
Yeah.
that's what I'm going to try and do.
Okay.
Um,
Interesting. I've not seen this before.
mhm. And
Present online, maybe? That one?
just going to,
Yeah, that one sometimes
no,
works too.
that's not it. I'm just going to
Okay.
switch the monitors.
Okay.
Uh, and let's see if that does it. Yep, that did it.
There we
Okay,
go.
we were all learning technology. Okay, so this program, as I said, is called Planning Without Fear, Wills, Trusts, and Estate Planning. So again, just to reiterate, this is a neutral presentation. I'm not permitted to give legal advice in a seminar, nor would I. And so even at the end, questions will be rendered into a neutral, answers will be rendered into a neutral form. And as I mentioned at the beginning, um, the packet or this handout does have a coupon for a no charge Zoom consultation. And if you are unable to get the packet in advance, you can certainly get it from the library afterwards. So the first question you have to ask is, why is someone delaying planning? And there's so many reasons, but I think it kind of comes down to um, four for me as a practitioner. So first is superstition, right? If I plan, it will happen to me. I think a really good example was sadly my sister-in-law's mother, who died many years ago, was convinced that if she signed a will, a power of attorney, or a healthcare proxy, something bad was going to happen to her. And what made it even sadder is that at the end of her life, as she was dying and needed nursing home care, the fact that she didn't have a power of attorney, which we'll talk about, or a healthcare proxy, made it so difficult for her two daughters and made their relationship very stressed. And it certainly didn't help that she didn't have a will. The other reason for delay is stories or experiences from the past. So often I'll see someone come into my office and I'll talk about their assets and, what happens after they pass away, how is it going to be distributed? And I'll get a comment like, well, 30 or 40 years ago, when my mother died, my uncle died, etc., we just walked into the bank. And I can never really know the true story, but I can tell you that what I say to them is that's not really a good reason not to plan. It's not a good reason to delay, because the world is so much more complex now, and banks and other institutions are so much more heavily regulated. Another reason people delay in planning is actually frightening advertising. And I also am on these mailing lists at my home. And so you'll get a card that says, make sure your assets go to the people you love. Don't let the government take away your assets. The government does not take away your assets. And you must have a trust to avoid probate, which we'll talk about being a terrible thing according to this advertising. So we're going to talk about this type of advertising in the context of my remarks, but that sort of advertising probably isn't a good idea to prompt you out of fear, but actually if it gets you to a good qualified attorney, then maybe you won't delay. And the last reason I hear is the cost of legal fees. And obviously, attorneys provide a service just like medical doctors treat you. So it is possible to shop for an attorney uh, based upon fees. But if you really are low income and do not have the money, there are two or three sources for obtaining legal services, including, for example, I believe Hofstra Law School has a legal clinic with students that are supervised by lawyers. Um, Touro Law School has a senior clinic in Suffolk County, and Nassau-Suffolk Law Services Committee has a senior division. In addition, the Nassau County Bar Association does have a program where lawyers sign up and agree to take fees at a reduced rate. So hopefully you're not going to delay your planning for any of these reasons at the end of this program. So what is an estate plan? So an estate plan is passing your assets after your death to persons or charities that you wish to benefit. And there's primarily two ways that we do that. We do that through wills, we do that through a living trust, or we do that through what we call testamentary trusts, which are inherited trusts. The other part of an estate plan is managing healthcare decisions if you become incapacitated, and that is a healthcare proxy and also can be a living will. And again, we're going to go through this much later in detail. And finally, an estate plan is also managing your finances if you become incapacitated. And that's a power of attorney. And for some people, it's a living trust. Now, what do I mean by incapacitated? Incapacitated can be temporary or permanent. So we saw very sadly during this COVID period, people who didn't have legal documents, and as a result of their COVID-19, particularly early on, they had no ability to pay bills, access funds, trigger insurance policies, etc. And if they didn't have a power of attorney, no one had authority to handle that for them. And that was some of them who recovered. It was a temporary incapacity. Permanent incapacity is more like things like dementia or Alzheimer's, where you're not going to recover and you've reached the point of not being able to manage finances. So first we're going to talk about wills. So the formal name is last will and testament. So this is a written document that's prepared by a lawyer who's admitted to practice law in the state where you live. So we're in New York State. So wills can be simple and provide for your family. They can appoint a guardian for minor children under age 18, and they can pass assets and income to the people that you want or to charities or both. Wills can also provide for estate tax planning for a married couple if their total of their assets exceeds the federal limits or the New York State limits. Now, in New York State right now, an individual can pass $5.8 million, a little bit more than that. And so you double that for a married couple, and they can pass an estate tax-free with proper estate tax planning. The federal limit is much higher. It's over $11 million per person. So wills can also create trusts within them. That's the testamentary trust for a beneficiary because they're a minor, maybe they're under 18, they're disabled, or maybe they're just not good with money. And it can create charitable related trusts. So wills are very powerful and they have the ability to cover a lot of desires, wishes, and needs. So what do we mean by a simple will? I mean, there's no such thing in law as a simple will, but people come in and they say to the lawyer, oh, I just need a simple will. So a simple will generally means you're leaving your assets to your known immediate family. It could be a spouse, your children. For people who don't have children, it could be nieces and nephews that you know about and are in your circle of your family. It can include charities. It can include distant relatives as long as you know who they are. The will directs who's going to manage the estate, and that's called the executor. And if the will has a trust, the testamentary or inherited trust, the will directs who's going to manage that trust, and that's called a trustee. Now, for children who are under age 18, and that could be your children, it could be grandchildren, you can, if you're the parents and you have children under 18, you can designate guardians for your children if both parents are deceased. And if, as a grandparent, and this is like a God forbid, except that unfortunately I've seen this happen, if the grandparent has been designated as the legal guardian and the children are minors under the age of 18, the grandparent is designating successor guardians in their will if possible. So you can designate guardians for minor children. For children who are 18 or older, there are no legal guardianships in a will. And if that child, that young adult, has any sort of developmental disability or is mentally incapacitated, that you cannot do in a will. You have to use a legal proceeding, and one type called 17A is for persons with developmental disabilities, and the other type, Article 81, is for someone who has any other sort of incapacity other than developmental disabilities, although we can do guardianships, Article 81 proceedings for children, young adults who have developmental disabilities, except that typically that's for people who have quite a large sum of money that needs to be managed. So can wills handle estate tax planning? And the answer is yes. So if you go back to the frightening advertising, don't let the government take your assets. The government's not interested in your assets. They're interested in whether there has to be estate tax paid when someone dies. So for married couples who own more than what New York State or the federal tax laws allow, You can establish tax planning trusts within the wills, and those are typically called bypass trusts, or sometimes they're called credit shelter trusts. And it shelters a certain amount of assets to the surviving spouse, so that when that surviving spouse dies, not only does the tax shelter trust pass without inheritance tax to the persons that the individual wants, that's been listed in the will, but it also passes the balance of the survivor's estate, hopefully without inheritance tax. For single individual, tax planning can be done very easily through gifts to charities. Anything that's given to a charity is not subject to inheritance tax. Now, there are a host of other very sophisticated methods for protecting large estates, but we're not going to review them in this program. So you've heard me use the term testamentary or inherited trusts under a will. So just like it sounds, the testamentary trust under a will captures the inheritance and has it managed for the person or persons under the terms that you've written in your will for their benefit. And as an aside, no minor under age 18 should ever inherit assets directly. And there's many who feel, including myself, that even some children, young adults between the ages of 25 and 30 may not be mature enough to handle an inheritance, but that's always going to be your choice. I know that some families call their under 30 receiving, God forbid, an inheritance, the little red sports car inheritance, which is their concern that the child is going to go off to Hawaii and buy a little red sports car and have a lot of fun and not have any funds before they know it. So when we do what's called a minor's trust, or a trust that extends for a certain number of years, it can be used for support and education, and typically the trust can be distributed as the child reaches either a specific age, and this includes a grandchild, or the money can be used in the discretion of the trustee and then distributed at a specific age. And if someone has more than one child or more than one grandchild, the lawyer will discuss with you how you want to set up that trust. Do you want like a pot where the trustee is just drawing on it as a child needs it, or a grandchild, or are you setting up individual accounts because someone might go to Yale, someone else might go to the University of Delaware, someone else might go to a state school. Now, if you have a disabled child or adult, or a disabled family member, someone who is receiving Social Security, disability, another type of program, SSI, or has a history of some level of disability, including mental illness, in New York State, you can create an inherited trust called a special needs trust or an Escher trust in your will. And that's a very important type of trust because it protects the inheritance from claims of the government, specifically Medicaid, but allows them the benefit of the inheritance to enhance their life. When we talk about special needs trusts, just like any other inherited trust, it springs to life when both parents are deceased or whoever is doing the will. If it could be an aunt, an uncle, a grandparent. Sometimes the trust, just like in a minor's trust, is funded from outside the will, such as life insurance, and it flows directly into the trust under the will. And a discussion of how to fund the trust and what with is usually important discussion with the lawyer who's preparing your will, so that the disabled individual, similar concern with a minor, a disabled individual doesn't accidentally inherit the money. And then, as I said before, the trust is used for the sole benefit of the disabled individual and doesn't affect their receipt of public benefits. The trust also does not stop when the individual turns 65. Now, there's the other type of trust I mentioned under a will can just be used to protect the person from themselves because maybe they're not good with money. Maybe they're easily influenced. Maybe there's a concern that the person they want to benefit, the heir, is married and lives in a community property state like Arizona or California. Um, or maybe the individual isn't disabled, but they have issues with drugs or other substances. So inherited trusts, which can continue for their lifetime, is a very good option. Now, I have a client who's about 92 now, and his parents were very wealthy, and they died a very long time ago. And he and his sister have lifetime trusts. And so he's 92 and he is terrible with money and he is easily influenced. But that trust is paying for his care because he couldn't give it away because it was in a protected trust with a trustee who is a trusted financial advisor, and that advisor has changed obviously over the years. So it's a good option to consider when you're discussing an estate plan with a lawyer. So once we understand about a will and what a will can do, the term of art is what passes through a will. So any type of asset or income can pass through a will. And asset or income that goes through a will means that it's only in the name of the deceased individual. So it's not joint with someone. Joint assets pass outside of the will to that joint with rights of survivorship owner. Or there's no beneficiary. So for example, if life insurance has a beneficiary, the money goes to that beneficiary. If life insurance says nothing, then it passes through the will. Same thing for a bank account. If it doesn't have a beneficiary and it's not joint, it passes through the will. Real estate, etc. So the most important part of your estate plan when you prepare a will is to make sure that you know what you want to pass through the will and to whom. So then we leave the world of wills and we go into what is called the world of living trusts. And a trust is a written legal document that you create while you're alive, right? It's different than an inherited trust that springs to life in your will. And the trust must be prepared by a lawyer. And the trust can also avoid probate of your will after your death. And probate means that you have a will, you have assets that have to pass through the will. A lawyer prepares a petition to the court asking them to accept the will as valid. The paperwork in the will and some other items are filed with the court. And if there's no objection from anyone, the court probates, accepts the will, and an executor is appointed. With a trust, there is no probate for what is captured by the trust. There are many different types of living trusts, but a few of them include a revocable living trust, a life insurance trust, an irrevocable Medicaid trust, a special needs trust, and a minors trust. Some of these terms may sound familiar. So let's talk about a revocable living trust. Revocable means it can be canceled or changed or amended. So you can be the creator of the trust. You can be the trustee, which means the manager. And you can also be the beneficiary. Now, the assets in the trust are not protected from creditors because you're in control. And that creditor also includes Medicaid. So if for a married couple who needs estate tax planning, you can prepare revocable trusts and have estate tax provisions in the trust, like we talked about before, like a bypass trust or a credit shelter trust, so that you minimize or avoid inheritance tax by doing this tax planning in both trusts. Just preparing a revocable trust without any estate tax language for a couple does not in and of itself minimize or prevent estate taxes. And that's kind of part of the false advertising that you get in those mailers. Now, if you become, excuse me, incapacitated and you cannot manage the trust as trustee, your document would likely designate a successor to manage what's in the trust. Now, a trust must be funded, and funded means you have to put something into your bowl, into your trust. You can put your home in the trust with a new deed. You can put a bank account in the trust or investment accounts by retitling them to the trust, etc. At your death, the trust acts like a will because it passes without probate the assets in the trust to the persons or charities or both that are designated in the document. It also directs that your debts will be paid. So sometimes trusts are called testamentary substitutes because they act like a will at your death, but there is no probate. Another type of living trust, which is less common now at present because the estate tax thresholds are so high, is an insurance trust. And this is a living trust. It is irrevocable, and it's designed to hold a life insurance policy. It owns the policy. And the trust, when the trust owns the policy, then when the insured dies, the monies are paid to the individuals listed in the trust, but it eliminates inheritance tax on those funds. Now, there's a lot of technicalities. The trust has to be drafted in a certain way. There are steps required to make sure the trust remains free from inheritance tax. And of course, only a lawyer can draft the trust, and the lawyer and you are usually working with a trusted insurance professional to properly title the policy to the trust or to transfer an existing policy. So again, another type of trust. An irrevocable Medicaid trust. So this is one of the most commonly talked about trusts. It's used to protect assets in the event that nursing home benefits are required. And unfortunately, it may also start to have to be used to protect income or assets if home assistance care called community Medicaid is needed in 2021. So you are the creator of the trust. You are the beneficiary because the trust gives you income, but you cannot be the trustee. You cannot be the manager. Now, when we say the trust gives you income, that is sometimes a little bit confusing. If the only thing that you funded the trust with is your home that you live in, and your home is your home, it's not a rental property, then keeping the income means if the trust is drafted properly, you're keeping the real estate tax reductions that you're already entitled to. And typically that's the VA reduction and STAR. If it's a rental property and you have rental income, then you are keeping the rental income. It's still your income, still being to be taxed on your personal return. Now, the well-drafted Medicaid trust usually gives you the right to remain in your home for your lifetime until you decide you want it sold. And if you do want it sold, many trusts are drafted so that a substitute residence can be purchased if that's what you want. Let's just say that you're downsizing and you want a condo. So in that regard, you would instruct your trustee to sell the home, and you would instruct them to purchase the condo that has a contract has been entered into. If you don't give them instructions to purchase a home or a condo or substitute residence, you can always give that instruction. And some families use the funds that are from the proceeds of a home, and they instruct the trustee to now invest the proceeds so that income is received because the individual is moving into assisted living, for example. And just as we've talked about with other trusts, at your death, the trust acts like a will and distributes the trust property to the persons in the document without probate. The well-drafted Medicaid trust preserves income and gift tax exclusions. And as I mentioned before, it's often called an irrevocable Medicaid trust for Medicaid protection. If you need nursing home care, the trust must be created and funded 5 years, 60 months before the need for nursing home care. And unfortunately, and unless the law is postponed, as of January 1st, 2021, trusts that are created and funded, in other words, starting in January, there is expected to be a delay of 30 months before you can apply for the Community Medicaid Home Care Program. So for trusts created until December 31st, that rule doesn't apply. As of January 1, it's going to be a parallel rule to the nursing home waiting period. Nursing home 60 months, home assistance 30 months. Okay, so whoops. So I'd like to go back for a minute to special needs trusts. The type that I'm going to talk about here is called, another word is called a gifting special needs trust. So sometimes we have an individual who is making gifts to, for example, their grandchildren, but they tell the lawyer that one of their grandchildren has special needs or is developmentally disabled or is expected to need Medicaid. So anyone can create this gifting special needs trust with their own and fund it with their own money. So it's almost like making a gift to the child, but you're making it to this special needs trust. And as long as the individual is disabled, these monies will not be counted if they ever need public benefits. You can create the trust, you can be the manager, trustee, or select someone else, and the trust continues after your death to receive gifts from anyone. They can also make gifts during their lifetime. For example, if other aunts and uncles or family members, it can also receive inheritances. So some people don't want to do a will with a special needs trust. They want the special needs trust now, a living special needs trust, gifting special needs trust, because they want to be able to make gifts to treat that child, grandchild, niece, nephew, etc., with the same equality of the other family members. And the key here is with the gifting special needs trust, Medicaid is not repaid at the death of the beneficiary because the money did not come from them, it came from other family members. So what can fund a revocable or irrevocable or a special needs trust? You can see on this slide, it's really pretty much anything. A home, condo, rental property, vacation home, anything involving real estate involves a new deed, investment accounts, cash, stock, a stream of income, if it's a business entity, out-of-state property. The only cautionary note I'll say is that with cooperatives, they do have the right to decline or refuse to transfer to an irrevocable type of trust. So you might have to consider other options if you're interested in a trust. And then depending upon the type of living trust, an accountant would be involved with telling you, what the income tax consequences are, if any, annually on the trust. For revocable, your life doesn't change. For Medicaid irrevocable, you're still paying the income on whatever comes out of the trust, assuming it's income that's earned, would have been earned by you otherwise. So I like to close out the section about passing assets to looking at other options, right? So do you need a will? Mm, most people do. It's kind of a safety net, even if you do what's on this slide. So for financial accounts, you can designate a beneficiary and not have a will or a trust. So for bank accounts, that's called POD, payable on death. You know, in the old days, it used to be called ITF and Trust for. And for investment accounts, that's called TOD, transfer on death. Very good way of passing assets and wealth, right? If you have no issues in your family, no one is a public benefit, everyone gets along, that sort of thing, this is a very easy way to pass wealth. Life insurance, annuities, IRAs, those sorts of retirement benefits, that's a beneficiary designation form that you get from the institution. And most of them allow you to name a primary beneficiary and a contingent or secondary. And again, very valid as long as you know that someone's not going to be receiving public benefits. It's a good option. As I said before, if you make accounts joint, maybe you only have 1 or 2 kids, and you can make those accounts joint with rights of survivorship. And then, of course, when we talk about real estate, one option is called a life estate deed transfer. And that's where you're taking your, well, any property, but we'll focus on your primary residence, and you're transferring it to typically your children. It's once it goes to nieces and nephews, I try and talk people out of it, but you're transferring your home or real property to 2 family members, 1 family member, just a family member. And within the deed, it says that you, so Beth Polner Abrams, returns the right to live and reside in this property for and during her natural life. So a life estate deed means that it's a transfer, just like the Medicaid trust. You have to stay out of a nursing home for 5 years. As of January 1, off of community Medicaid for 30 months. If it's a rental property, you still get the income because that's what a life estate recipient or owner is entitled to. And because you have the life estate, no one can force you to sell the property, only you have the right to sell it. And at your death, the property passes automatically to the persons at the top of the deed, the remainder persons. In other words, if it was your children you gave the property to, subject to your life estate, it then flows to them. So it has all the advantages of a trust. There are some disadvantages unrelated to this program. More if the house is sold, how much you don't get all the money. You only get a fractional share based upon your age and an IRS table. Okay, so we move out of estate planning and we move back into what we call advanced directives. So how are you going to manage healthcare decisions if you become incapacitated? And that is the healthcare proxy. So the beauty of a healthcare proxy is that you do not need a lawyer to prepare it. And on the slide, you can see, you can get the document from your doctor, you can get it through the internet from the New York State Bar Association or the New York State Department of Health. You type in on their website, healthcare proxy form, and the form comes up. You can print it with instructions. And obviously, if you're doing planning with a lawyer, the lawyer will prepare the form. So healthcare proxy covers all medical decisions, not just end of life, when you cannot tell a doctor what kind of care you want. And a doctor determines, a nurse or social worker, that you lack medical competence to make decisions. And that's when it kind of springs to life. And as well, if you're doing your own healthcare proxy, you can see that the other beauty of the healthcare proxy is that it's witnessed by two people and not notarized. Now, what kind of decisions can your healthcare proxy make once a doctor, nurse, social worker, et cetera, certify that you're unable to make medical choices? So you can see it really runs the arc of care: surgery, biopsy, anesthesia, medication, routine medical exams, feeding tubes, which New York State calls artificial nutrition and hydration, intubation, which was a huge issue for COVID, and other end of life decisions, withdrawal of life support, palliative care, etc. Now, if an individual is in a hospital or a nursing home and does not have a healthcare proxy, New York State has a separate law, as do many states, that allows a prioritized list of individuals to make medical choices. So other than a healthcare proxy and a legal guardian, spouse, then child, etc., down the list. So a healthcare proxy becomes critical when you're not in an institution and medical decisions have to be made. Think of someone with dementia who can't make a decision about medication or treatment and can't communicate that they want their eldest daughter to see their medical information and hear it. So all of that is comprised in the healthcare proxy. And I would urge you to try and, even if you're not going to do planning, this would be an important document. It's online to secure. And finally, we get to the power of attorney, or financial power of attorney. So again, this is a legal document. It must be prepared by a lawyer. It is to allow someone called your power of attorney or your agent to handle financial decisions, bill paying, taking care of your assets, speaking to insurance companies, filing claims under insurance of any type, talking to the New York State retirement system, etc., when you can't. You can designate more than one person to be your power of attorney. You can have backups. When does it spring to life? It springs to life, in other words, when the power of attorney can act, either when they sign the document, there's actually a page where they sign it in front of a notary, or they sign that in front of the notary because you've asked them to, right? So I think of my dad, who's no longer alive, and towards the end of his life, he was homebound. And the few things that I needed to take care of for him, as his power of attorney, he signed the document so that I could handle certain insurance matters for him, right? Or, as I said before, or alluded to before, if you walk into a family member's home and you see mail, rotting food, you know that this person is not managing their bills, you don't need permission from the individual to go trigger the power of attorney. In other words, sign it in front of a notary. So the document, when you sign it, which is important to have, usually stays in your possession or the lawyer's possession. And when you want your agents to be able to act for you, then you would have them sign the document in front of a notary. Now, the form changed in 2010. There were 3 parts. There's the statutory form, which is the basic power of attorney. There's modification section, which is where lawyers put in additional powers that they feel are necessary to give your agent. And then there was something added called the statutory gift rider, and that allows for gifts for estate tax planning. And it also allows for various Medicaid strategies. If someone says, look, I'm not doing a Medicaid trust, I'm not giving my money away, but if I ever need Medicaid, this power of attorney will allow you to do legal planning. And legal planning for Medicaid is gifting. So it's within the document. So what if your power of attorney was created before 2010? So you really just have to take the time to pull it out. Check to see if the people who you designated as agents are still alive, are still around, are still the people that you want involved in your life. Check to see if it's valid. In other words, did you walk into, which you can't do anymore, a stationery store and just do it by hand? You got to make sure it's valid. A lawyer can tell you that. And check to see if the powers in the document are broad enough to cover your needs now and sufficient to protect you both now and in the future. So I've left plenty of time for questions, but in conclusion, I really feel that the best plan for anyone is to take the time for proper estate planning, legal advice, and counsel with a qualified estate planning attorney and determine what planning is needed, if any. Fear should not be your motivator. Control of your life, control of your legal future, and control of your decisions in the future should be paramount.